Good evening and welcome. My name is Kieron Beal. It's perhaps a little incongruous to have a group of lawyers giving a lecture in church. I'm reminded of a story of three people who died and were before the gates of heaven. They were a priest, a doctor, and a lawyer. They met St. Peter, who said he would let them in to through the gates of heaven if they could each answer one simple question. Peter asked the priest, "What was the unsinkable ship that struck an iceberg?" The priest replied, "The Titanic," and the gates opened. Next, Peter asked the doctor, "How many people died on the Titanic?" The doctor replied, 1,503, and the gates opened. Turning to the lawyer, St. Peter then said, "Right, you, name them all." Anyway, we're exceptionally lucky tonight to have a star-studded panel of speakers for you. I'm delighted to welcome, from my right, Adrian Berry from Garden Court Chambers, Helen Davies QC from Brick Court Chambers, Belinda McRae from 20 Essex, Mark Summers QC from Matrix, and Naina Patel from Blackstone Chambers. We're joined online and by people here in person in the Temple Church. Speaking personally, I'm delighted to have people back in person. It's lovely to see you all, and I hope that it won't be too long before we'll be able to welcome you back to the renewed Inn. The event's being recorded and will appear on in the Temple website in the coming days, and a link will be sent to all guests afterwards. In the event of an emergency, please could you depart through the door you came through at the south entrance. If you've got any problems, please just speak to Jenny and we will try and sort you out. For those of you joining within the church during the talks, please can you try and think about any questions you may have for us. We're here to help you with your nascent practices. And for those of you joining on the webinar, please use the Q&A function on your screen. You can submit a question at any time, and the selection of questions will then be put to us by Jenny, and we'll do our best to answer them. Please could you try and keep any questions concise, because I think by then we'll be a little tight for time. Now, rather than introduce each of my speakers in one foul swoop at the front of this talk, what I'm proposing to do is to speak to you very briefly about EU law, such as it is these days, and then introduce each of our amazing speakers one by one. So starting, if I may, with my presentation on EU law, what I'm going to do is I'm going to explain to you briefly how I started off in EU law. I will explain some of the issues that have arisen in practice. I'll then try and identify some areas of relevance for you as young practitioners. You may be thinking, well, post-Brexit, why does any of this matter? The answer is there are one or two areas where it still applies, and so I'll cover those with you. And then finally, I'll mention briefly the alternative European jurisdiction, which is the European Court of Human Rights in Strasbourg. Turning then to how I became an EU law practitioner. Well, it seems a long time ago, but I studied EU law at university, and I completed a dissertation in law and economics, and the dissertation supervisor I was assigned was an up-and-coming practitioner and academic called Eleanor Sharpston, who became Advocate General at the Court of Justice in Luxembourg later in her career. She persuaded me to commence my pupillage with her at Hailsham Chambers, what is now Hailsham Chambers, and one of the first things I got to do with her was a challenge to the legality of the Working Time Directive in 1996. And I travelled by train, because I couldn't afford the plane fare, to Luxembourg to go and see her in action with Michael Beloff. That then prompted me, through Eleanor and Hailsham, to become a government lawyer on a number of occasions, and I picked up EU work ad hoc through that. What I've also found very useful in my career was joining specialist bar associations and the relevant circuit. So there is a specialist bar association which is excellent and active called the Bar European Group, which a number of us on this side of the panel are members of. There's also the European Circuit, which is also thoroughly useful. Finally, if you're more internationalist in flavour, there's the European Law Institute, which is currently run by Lord Thomas, the former Lord Chief Justice. Issues in practice. Well, as with any foreign jurisdiction, one of the key things is to familiarise yourself with the specific rules of procedure that govern the jurisdiction that you're looking at. In Luxembourg, there are very detailed rules and guidance for both the Court of Justice of the European Union and the General Court, and I would encourage all practitioners to familiarise themselves with that if you have a case going to the courts in Luxembourg. The written pleading procedure is different, substantially different from the UK procedure. There are strict page limits that apply for every type of procedure that you have before the Luxembourg courts. So in a standard application for annulment of an EU decision, you are constrained to 50 pages. That may sound like quite a lot, but actually if it's a very complex competition law case or state aid case, you find you run out of space quite quickly. And those limits will be strictly enforced against you. Otherwise, they effectively direct you to resubmit a pleading with the verbiage cut out. Oral advocacy is also different. There are strict time constraints for the hearings before the Luxembourg courts. Typically, in the Court of Justice, on a reference from a member state, you are constrained to 20 minutes. You have to keep your language simple because it's translated into many different EU law languages. And you also have to make sure that, for example, you don't try and tell a joke because that doesn't translate very well, invariably. There's a famous case that was told to me by Eleanor, who was sitting in the court when she was referendaire for Gordon Slynn. And there'd been a rather old-fashioned Rumpole-esque QC who had turned up from London and who was making his presentation. And at one point during his submissions, he sort of giggled to himself and said, well, my lords, of course, sauce for the goose is sauce for the gander. And Eleanor was listening to the French translation, and it came through from the French translator, English counsel has just made a joke about poultry. So you have to be very careful what language you use and what you say. Also bear in mind that these large international supranational courts will know the case law back to front for their jurisdiction. So you don't have to worry so much about that. What they're actually going to be interested in is policy issues. How is this going to affect the relationship between member states? What is the overarching EU law narrative for taking a decision one way or the other? And that's what they're going to be particularly interested in, recognizing the harmonized nature of EU law and giving an EU-compliant answer. Next, is EU law still relevant? Well, it's fair to say that the Brexit vote was probably not the most auspicious day in my practice as an EU law practitioner, and does present challenges, not least impending early retirement. But putting that to one side, I have just finished a judicial review for an interested party in a case that was brought by British Sugar. And it was brought against the government because the government had given a duty-free autonomous tariff quota for imports of raw cane sugar for refining. And my client, Tate & Lyle, was identified as being a beneficiary of that quota, and British Sugar said, this is a subsidy. You, the government, have given Tate & Lyle a subsidy because they back Brexit and you like them. And they also said, it's a state aid caught by the Northern Ireland Protocol. What I think many practitioners post-Brexit would not have appreciated was that indeed that was an argument that was capable of being run. So Mr. Justice Foxton, in a judgment delivered last week, found that in principle a tariff quota under the UK's new tariff regime could be caught by EU state aid law if there was a genuine and direct effect on trade between the EU and Northern Ireland. What was even more surprising, perhaps, was the admittedly not very strongly advanced suggestion that the court could make a reference to Luxembourg on a state aid issue caught by the Northern Ireland Protocol by virtue of Article 12, subparagraph 4 of that protocol. So you might think that references to Luxembourg are dead, and certainly we're on the tail end of references coming through from the EU courts. But find the right case involving the Northern Ireland Protocol and one of the areas caught by the Northern Ireland Protocol, and you could find yourself back in Luxembourg after all. Next, the EU-UK Withdrawal Agreement, Article 87, also allows the Commission to take decisions that we have infringed EU law, and they can do so for up to 4 years post-Brexit. So the UK would have to challenge any such decision before the Luxembourg courts. So that's another avenue. How would you get involved with EU law issues more generally? Well, you would need to have a detailed analysis of the 2018 European Union Withdrawal Act and also the EU Future Relationship Act 2020. What you may find, looking through the Trade and Cooperation Agreement between the EU and the UK, is there's lots of good legal points there for you and your clients, which you may be able to run if you read Section 29 of the 2020 Act. And realize that, in fact, in quite a lot of circumstances, you can deploy principles from the TCA, the Trade and Cooperation Agreement, directly in English courts. So worth bearing that in mind. Finally, some quick thoughts on Strasbourg. Strasbourg will probably feature in your practice quite a lot, regardless of the area of law you do. You will all be familiar with the Convention and the Convention rights, and you will find in all areas of crime, family and civil proceedings, there will be scope for a Strasbourg argument at some point. Once you've exhausted domestic remedies, i.e. you've lost as much as you can lose, then you then have 6 months within which to bring a complaint before the Strasbourg court and challenge the decision that's gone against you. So also bear in mind that if you're, for example, doing work for NGOs, you can find out that there might be a Strasbourg route for you. One of the joys I've had as an EU law practitioner is meeting other EU law practitioners from other states. I've spent many years judging a mooting competition held in Central and Eastern Europe. It was set up by the late Lord Slynn. It's now presided over by Eleanor Sharpston, and she's called me over to help with some of the judging. One of the particularly delightful moments we had in 2019 was to have the final before the Luxembourg Court, the Court of Justice of the European Union, in the Grand Chamber, which is a very grand building with a very large upturned jellyfish as a sculpture at the top of the ceiling. What, in current circumstances, you may be pleased to hear is that there was a semi-final between a team from Kiev Moyla Academy and a team from Moscow State University. And they managed to conduct it in a wonderful spirit of camaraderie, respecting the rule of law. And I think we all hope such events can be back on the agenda as soon as possible. I'm now going to invite Adrian Berry to give his presentation. We're delighted to have Adrian with us. He was called to the bar by Inner Temple in 1998. He practices from Garden Court Chambers in a wide range of immigration and citizenship issues. He's particularly expert on British nationality law, and he regularly advises on the conflict of nationality laws for people with multiple nationalities. He's a member of the Advisory Council of the European Network on Statelessness, and he acts for clients with complex and sensitive asylum and international protection issues. Absolutely delighted to have Adrian present to you, and he will now share his thoughts.
Thank you very much. So, as far as international law works in my practice, I'm dealing really with mobility and migration issues, issues of citizenship, and issues that are connected to that. And it can include the things that accompany people when they move across borders. So it can be things like social security contributions, how do they move them across borders, how do they move their families across borders, and so on. And so the issues start off not only about how do I apply to go and be somewhere else, but once I get there, how do I secure my place there, how do I achieve permanent residence, and ultimately perhaps citizenship. And that can involve a number of instruments of international law. And it depends on the subject area. If you look at migration, you can break it down into economic migration, international protection issues such as refugee status and asylum, and family reunion. And then capping that will be citizenship issues. And so the sorts of international instruments that you use will vary. So in protection cases, you'll be looking at the Refugee Convention, human rights instruments like the Convention on Human Rights in the European region, and any forms of complementary protection which exist in international law, such as the humanitarian protection that was in the Refugee Qualification Directive from the European Union when it applied in the UK. So you get some sources of international protection law there, and you'll get some in citizenship issues, such as the Convention on Statelessness and the Convention on the Reduction of Statelessness. And so those things apply here in our law, and they apply to people that move here and seek protection or effective protection under the Refugee Convention or substitutory protection under the Statelessness Convention. So you see in that field of protection a lot of international law instruments that we'd use, and they are justiciable and directly effective or transposed into UK law in different sorts of ways. And it can be quite, one of the interesting issues if you work in the field of protection is the different ways that different international instruments resonate in our domestic law and how useful they are. And then even in economic migration, there's a lot of international law. I mean, famously, of course, when we were in the European Union, there was free movement and free movement of persons as one of the four pillars of one of the four freedoms of EU law. And that still continues to have some effect as an international legal aspect of practice now. Under the citizens' rights section of the withdrawal agreement, you can still have references for 8 years from the end of the Brexit transition period to the Court of Justice. So I may not have made my final appearance there in a free movement case. And also under the, and so there will be some cases that come from there, but also there is a coordination of social security section of the withdrawal agreement, which also is attached to citizens' rights and can also have some continuing effect. But essentially that area is declining and will expire after the end of the 8 years. But under the Trade and Cooperation Agreement, there are mobility provisions. They're not as effective as, or not nearly as far-reaching as the free movement provisions that were existing under the EU treaties, but there are some, and they relate to short-term mobility for service provision. If you're a barrister, moving as an independent professional for up to a year at a time, and they define various in terms of the General Agreement on Trade and Services, what you call Mode 4 mobility provisions, which exist. And this treaty is international law rather than European Union law, and so it has a slightly different relationship in our domestic order, but nonetheless, there are still some international law provisions which you would use in the field of economic mobility. And then with family reunion issues in migration, that's probably the sort of the poor relation of the two. There are fewer, and you tend to fall back on human rights provisions, and so and have to rely on that rather than having there is no real international migration treaty as such, as a universal instrument or as a regional instrument in the same way. Occasionally, you also find that there are things which crop up which can be very useful. So, for example, the UK allows you to bring a petition to the Committee on the Elimination of Discrimination Against Women, and there are some residual pockets of discrimination on grounds of sex in British nationality law. So you can find yourself, if you've exhausted a remedy, trying to domestically drafting a petition to that committee rather than to the Court of Human Rights. And so sometimes you have to look around for the things which might be available in difficult situations. And it can be a very topical form of work. I fell into it because my original undergraduate degree was in international relations and history, and the subjects you could take were European Union, the politics and integration of the European Union, European security, international terrorism, that sort of thing. And all of those topics are very good if you end up being a lawyer, a barrister, or a solicitor who works in international mobility issues, because in international protection cases you need to be able to assess the risks or the evidence of risk of persecution or harm in foreign countries, and you need to be able to work on background evidence to that. And in terms of working on free movement cases and mobility for economic reasons, even though the EU, of course, we're no longer in it, but it is an example of a developed system with economic migration provisions in it, and it gets you into thinking about how mobility works in the field of economic migration. So it's a good, I had to sort of bridge, if you like, and my intention until I switched to do the law conversion course was never actually to be a lawyer, but to do something else. And so I fell into it on the basis of deciding not to do a PhD in history. I decided to do something useful with my life, and I thought, well, what about the bar? And I hope that's been a good decision in that respect. But what I wanted to do was to take the areas of interest and concern, and I thought, well, maybe I'd like to be what I thought of as a civil liberties lawyer, but I really didn't have any clue what that was at the time. Except when I now look back, I can see how a bit naive it was. But actually, what you're really talking about, if you're coming to look at international law through, in terms of mobility, migration, and citizenship. It's talking about looking at public law and administrative law and then bridging out or broadening it out into the international field of practice that you seek, where your interest lies. So you can't really work in the fields of citizenship and migration unless you're also essentially a public lawyer in the domestic sense, because that's what you'll end up doing for a lot of the time. So if you look at something like someone who moves for the purposes of international protection, if they become a refugee and they're granted asylum in the UK, there are standards of protection in the Refugee Convention which give them entitlements on an in-country basis. So you might not just be looking at the question of whether or not that person is a refugee, but you might be also looking at the question of whether or not they have an entitlement to homelessness assistance on an equal basis with British citizens or with lawfully resident aliens, and whether they can rely on that in order to achieve a particular result. So it's not just the crossing of the border, it's not just the granting of lawful residence, but there's forms of attachment which come with that. And the package, when someone moves, they require other things. They need, so for example, in the context of economic migration, if you look at the Trade and Cooperation Agreement, you'll see that there's a protocol on social security integrated into it. And it sounds very boring, but if you pay your national insurance contributions in one country, you need to be able to draw down on them and aggregate in another country so you can claim your contribution-based social security and pension entitlements in the country where you move to work. And so it really does mean that although you're dealing with people who move, and one way you can describe it as immigration, it's really about mobility and the things that people do in order to build their lives in the round once they've moved as well. The other thing, just briefly in the time available, is to say that citizenship is also increasingly important because it's the ultimate form of attachment. And so although it's a small area of mobility practice, there's an increasing body of law surrounding it, not least deriving from people who have multiple citizenships and how they can use those effectively and the effect that has on their international protection claims and ultimately, if they're not careful, on their ability or to resist extradition, which we're going to hear from separately. So it is very interesting. I would encourage people to do it, but always bear in mind that you'll be a public lawyer first and an international lawyer second. Thank you.
Thank you very much. I'm sure there'll be lots of questions about immigration and migration issues from the audience in a moment. We're next going to hear from Mark Summers QC. He is a barrister at Matrix Chambers. He was called by the Inner Temple in 1996 and took silk in 2014. He's a leading international criminal law expert and was previously chair of the Extradition Lawyers Association. He regularly acts for individuals and foreign governments in extradition cases, and he also regularly prosecutes and defends high-profile cross-border complex fraud cases. His caseload has included cases such as the Julian Assange case, the attempted regicide of the King of Spain, the 9/11 attacks, and pertinently, perhaps in the current context, KGB espionage in the former Soviet bloc. Let's hear from Mark.
Good evening. So my work is international crime, extradition with a sideline in terrorism. I spend most of my time advising or representing foreign governments or defendants in cases that are primarily based in the UK and only occasionally abroad. When they are abroad, it's quite infrequent that you appear in a foreign court. You're more often advising foreign lawyers who can and do appear, though. Now, everyone knows what extradition is. It's the process of getting a defendant from where he is or where she is to where another state thinks they frankly ought to be. How did I get involved in it? In one sense, I think I'm going to be the least useful panelist tonight, because I think the answer, frankly, to that is poor choices and luck. So let's start with my poor choices. My degree, I failed entirely to follow the advice I always give to people who ask, which is study what excites you and then transfer to law later. With hindsight, I should have studied SPS, My heart's always been in politics, human geography, sociology, and I failed entirely to follow my own advice and have spent the last 20 years seeking outlets to bring those things within my day-to-day practice. My next poor choice was not to take a year out abroad and travel. That opportunity never ever comes around again in that way, and I still look at maps and wish I'd gone there or still could go there. So whereas my daughter now is studying SPS, I've been politicking and travelling entirely vicariously through my files in my room ever since. Each new extradition case for me is a journey not only somewhere new, but into the politics and people of somewhere new. So how did I manage to narrow that down, or my practice down, to international crime in the form of extradition and terrorism? And that, I'm afraid, entirely or equally unhelpfully for you, is pure happenstance. So I started off in general crime. I did my time learning trial and cross-examination craft. I threw myself into cases when I could, and one of them happened to be assisting a member of Chambers on an extradition case. And as with all niches, once you've done one case deeply and properly, you're broadly equipped to do the next one that comes along. And once you've done two, you're an expert. And if you're doing your job right, things snowball from there. And that's what happened to me with a grisly murder, with a bloody dumbbell from Vancouver and a confession secured by an ingenious police entrapment. It was all entirely fascinating, and so I fell into extradition. And the same with terrorism, hijacking trial involving families fleeing Taliban persecution about 5 years into my practice at a time when no one knew who the Taliban were. And here I am many, many years later. Extradition's about 80% of what I do, and my study or my office is a new journey from my lost gap year every time I go into it. What carried these two particular areas? From what I've just said, I suspect it won't be much of a surprise: international politics. So state political motivation is a defence to any extradition case, and frankly it's difficult to tire of immersing yourself in the struggles of an ETA operative in Spain, or Sikh separatists in India, or political corruption in Mexico. It just never gets dull. So I've been asked to offer some pearls of wisdom for career development from that rather Forrest Gump tale for any would-be criminal practitioner, and I suspect from the audience it's a bit too late to persuade you to take that year out and travel, and I suspect it's entirely too late to persuade you to do a different degree. So I think I've only got 4 after those two. So one, at least for crime, don't think you have to specialise too early. Advocacy skills are crucial. International crime is no different from any other sort of crime. You need to be able to cross-examine experts, you need to be able to cross-examine defendants, and you can't do either of those if you haven't done some general criminal work, if you haven't done your time in the courts. And if you can't do those well, your extradition career or your international crime career will be entirely short-lived. So 2, don't only do extradition. For much the same reasons, a narrow focus means, I've always thought, a narrow knowledge base. You need to know criminal law inside out, not just extradition procedure. It's the same with any niche area, in frankly any area, but take fraud within crime, for example. You can't just do fraud. You've got to have a broader knowledge base than that. How can you, for example, formulate an argument about how the elements of Slovakian environmental crime marry those that operate in England if you don't know what the rules are in England, if you've never done an ordinary UK criminal case? So don't be so keen to specialise too early, and don't only do one very narrow area of law. Thirdly, these things, I think, are symbiotic. Doing some international criminal law work will make you generally a better criminal lawyer. Take my Canadian case, for example. Learning about Canadian entrapment law was entirely fascinating in its own right. but it broadened my knowledge of the law of entrapment. It made me understand how courts in another country would approach it. And fast forward 15 years, and I currently have an extant challenge before Strasbourg to the UK law on who bears the burden of proof in a terrorism entrapment case, by reference to that comparative Canadian law I picked up 15 years ago and then went back and did some more research on. So these things just feed each other. And if you do a bit of international law, or there's an aspect of international law to your practice, it will benefit the rest of your practice. And lastly and fourthly, this, even if your practice is not recognisably international, have patience. International practice can take many forms. For many people, it means doing what you do, but in courts overseas. And that kind of international exposure comes to everybody good eventually. So even if you spend your first 15 years doing entirely domestic criminal work, if you are pushing yourself, if you are pushing and pursuing novel legal arguments whenever you can, if you excel, if you innovate with the law, if you pursue points to the Supreme Court, eventually and inevitably you will come across the radar of that law firm in Trinidad or Tobago or Singapore looking to present their Privy Council case, or looking for somebody to come and assist their local legal team. And in that way, I'm afraid international criminal law will catch up with you, like it or not. There's much more I could say, but I've only been given 10 minutes, so that's all I will say. Thank you.
Thank you very much indeed. As with Adrian, I'm sure there'll be plenty of questions on that. For the next two speakers, I'm going to do a joint introduction, because they are going to top and tail each other, and there may well be a little bit of dynamic competition between them as to the perspectives they give you from a silk and from a leading junior perspective. So Belinda on my left was called to the bar by Inner Temple in 2014. She's a barrister at 20 Essex, as I said. She has a particular specialisation in private international law, public international law, and international arbitration. She's both sat as an arbitrator, and she has appeared as an advocate in arbitrations in more destinations than my children have been on holiday to. So they include London, Paris, New York, of course, but also Lausanne, Geneva, Kuala Lumpur, The Hague, and Cairo. She started her career as an associate at Freshfields in Paris, where she specialised in international arbitration, before happily joining the bar and blessing us with her presence. She also does EU law as well, but that's not on her blog. I've seen her give some excellent talks for the Bar European Group. Helen Davies, QC on my right, leads Little Introduction as the joint head of Brick Court Chambers. She's got an extensive commercial litigation practice, features as well in EU and competition law cases, regulatory public law cases, and pretty much most of the significant commercial disputes I think I've seen in the commercial court in the last 10 years or so. So Helen's always got an involvement somewhere with them. She's appeared in numerous commercial arbitrations, international and domestic, and she's recommended by all the directories for the star she is. I have to say about Helen, every time I appear against her, I lose. And so I'm quite looking forward to a career advancement, to actually do something with her at some point. Anyway, we're going to hear from Belinda first. Helen will then give her views, and there may be a bit of crossover, so I'm sorry if I come between them.
Thanks very much, Kieron. It's lovely to see you all in person and the rest of you to imagine you online. So 3 things I want to discuss today. First of all, give you a little bit more of a flavour about my practice, and in particular arbitration and that element of it. Second, I want to speak to you about why I wanted to work in international commercial arbitration, to give you an idea of what might entice you to do the same, and why in particular I enjoy it now. And third, I'm going to address how, in my humble experience, to develop a practice in arbitration, and give you some tips about what you might do in your position to sort of pursue a career in that area. So to start off then, as Kieron mentioned, I'm a barrister of a measly 7 years call, I think. I'm at 20 Essex, which I'm happy to say is one of the chambers that does specialise in arbitration, so it's a good sort of starting point for a career in this area. And I should reiterate that I'm very much the warm-up act to Helen, who can tell you about the practice of arbitration from far loftier heights than mine. As Kieron mentioned, I used to be a solicitor before I came to the bar. I was at Freshfields in Paris, specialising in arbitration and PIL, or public international law. From my nasal twang, you can tell that I'm Australian. So I started off my career then and sort of moved to London, which is a far more fascinating jurisdiction in this area in particular, and have since happily stayed here. I came to the bar really for two reasons. First and most obviously, I wanted to focus more on advocacy rather than the compilation of bundles and other such exciting activity. But second, and I guess something that was really close to my heart, is I wanted to have a more diverse offering in the work that I did. And that's something that I found the commercial bar in particular really to offer. I found when I was a solicitor, I was focusing very specifically on a limited area of practice, and I thought that that didn't assist me in my own professional development. So what do I do now that I'm at the bar? I principally focus on four main areas. I do commercial litigation before the Commercial Court and the Chancery Division, sometimes touching on EU law, a lot of civil fraud, financial services disputes, really whatever someone is willing to give me to argue, I'm not fussed. I second do international arbitration, and both the commercial side of things, which I'm going to talk about today, and also investment treaty arbitration, so disputes between individual investors, be they people or companies, and states, under bilateral or multilateral investment treaties. I also have a very small and unglamorous practice as an arbitrator, which is a lot of fun. The third thing I do is arbitration claims before the commercial court. This was something I was particularly keen to do in this jurisdiction that I didn't have the opportunity to do as a solicitor. And it's a really nice way of combining an interest in arbitration with the sort of comfortable rigidity of the CPR and the expertise of the wonderful judges at the commercial court. The fourth thing I do then, which Naina is going to focus on in particular, is PIL broadly. So domestic disputes before different courts in this jurisdiction, be they the admin court, family courts, commercial court, really whatever, and more international disputes, be they before the ICJ or international arbitral tribunals. So that's me, and the message I think you can take away from this is that I have a very short attention span. I don't like doing one thing, and I very much sort of subscribe to what Mark says, that it's better to develop one's skills across a wide variety of practice areas. So, what does international commercial arbitration involve, at least as I experience it? Commercial arbitration, as you might anticipate, involves a huge number of disputes across a very wide sector. So what I sort of look at from one end of the spectrum is small commercial cases in which I sit as arbitrator, for example, for the recovery of unpaid student loan debts. Really, really unglamorous, I should emphasize. So those kinds of things that bring up all sorts of interesting procedural issues, for example, when the respondent refuses to participate. And then at the other end of the spectrum, there are large commercial disputes between governments sometimes. I've been involved in one long-running dispute, to give you an example, between the US government and the Iranian government in an arbitration that's seated in The Hague before a 9-person tribunal that is worth many billion dollars and arises out of a large series of commercial contracts for the sale of foreign military equipment and services. So the nice thing about arbitration of the commercial variety is that you never get bored. In terms of what I enjoy about arbitration and why I wanted to work in it, I think, like many, I started my legal career in a library researching a mooting problem and came across arbitration for the first time. In that example, it was all about expropriation of a company's sort of shareholding. And as a result of that experience, I competed in a moot, spoke to a few people at that mooting competition, and then it led to an internship, and things sort of snowballed from there. And I would say the fact I think that there are two people on this panel speaking about international commercial arbitration just really tells you that it's the real game in town in terms of international practice, and it's absolutely fascinating. But let me give you 3 specific reasons about why I enjoy it. The first is, I think, that it's very obviously a party-led process. It's meant to be a flexible instrument. And this means that there's huge scope for creative thinking, both as an advocate and client advisor, from really significant things like the identity of your tribunal members to boring procedural things that can really make a difference, like timetabling, whether or not you're going to have fact witnesses, expert witnesses, applicable law, those kinds of things. Second, in any large international arbitration, you'll face counsel, tribunal members, and party representatives from different legal traditions across the globe. And one of the fun things, I think, which is, I'm sure, an element in many of my colleagues' areas of practice, is you're developing your arguments to someone, in front of someone who might come from an entirely different legal background, and you have to be clear, concise, and adaptable, even if, for example, their experience is sort of a civil law tradition, and they're not used to cross-examination of witnesses in the style to which we might be accustomed. Third, I think in international commercial arbitration, the quality, scale, and political dimension of the work is hugely fascinating. Parties often opt to resolve their disputes by way of arbitration because of the sensitivity involved in them, which means it's quite a lot of fun for you as the lawyer getting to grips with the facts behind the problem. So, let me give you now some tips about practice development. When I started out at the bar, I had all sorts of wonderful ideas about how I was going to do it. Embarrassingly, I even had a business plan, which I presented to my clerks on day 1. I think they had no idea what had hit them. I was really very keen. I think one thing I have learnt that might be of assistance is one thing that you're told is how important external marketing is in developing a practice, but I've found in my own experience that one of the most significant things really is internal marketing within chambers, actually ensuring that your silks get to know you, you demonstrate an interest in a particular area so that you can be the person at the forefront of their minds when they're considering who to pick as their next junior. But let me give you 6 sort of more general tips when you're starting off as a student, perhaps. First of all, look out for any arbitration-specific internships that might be offered. This is how I started out, and I found it a really useful way to go about it. There are specific firms like 3 Crowns who only do arbitration. There are others that do it in the broad scope of their work. Second, there are a number of sort of youth-focused arbitration groups and institutions who have a lot of lectures, seminars, social events on offer, such as WIAG in London, and I really recommend getting involved with them if you can. If you do realise that you have an interest in arbitration through these sorts of experiences, do try, if you have the opportunity, to gain a position as a tribunal secretary or research assistant to an arbitrator. It's a wonderful way of honing your sort of procedural skills and being exposed to someone with much greater experience than yourself. Fourth, if you're still a student and have the opportunity, I'd highly recommend the VISMOOT, which is arbitration specific, and is a great opportunity to meet practitioners, learn from them, and of course, perfect your advocacy skills. Fifth, attend conferences if you can, write, speak, blog, whatever you can be bothered to do. It's all really useful and helpful in building your profile. And sixth, I think most importantly, if you ever have the opportunity to be involved in arbitration, really grasp it with 2 hands and absorb all you can through that process and use that experience as a stepping stone to your next instruction. So with that, I'll hand over to Helen and hear all about her and more exciting experiences.
Thanks, Belinda. Well, as both Kieron and Belinda have alluded to, I'm going to be speaking from the more senior end of practice at international commercial arbitration, which basically means I've been practicing for a very long time. In fact, I scarily realise that it is now 30 years ago almost, exactly 30 years ago this year, since I was doing my pupillage and I first attended an international commercial arbitration. I got into international commercial arbitration because I was doing peerage at Brick Court. And I didn't, when I was a student, didn't really think very much about why commercial sets do international commercial arbitration. But of course, once I was in practice, realized, well, actually, there's a short answer to that. The foundation of any international commercial arbitration, or in fact any arbitration, is a contract. And all that's happened in those disputes is that the parties have chosen arbitration as the dispute resolution method as opposed to court jurisdiction because they want to keep their dispute private. They don't want to wash their laundry in the public sphere. That means that any commercial lawyer will actually be an arbitration lawyer as well because their client, I mean, one of the early clients I had was BP. Their disputes are either English jurisdiction clauses or arbitration clauses. You have to be able to do both if you're going to be able to act for them. So it's interchangeable, really, as a commercial practitioner, those cases. And you can't pick or choose in the sense that you can't say, I only want to do litigation, because you're cutting off some of your clients' disputes, which obviously you don't want to do, nor can you actually sensibly choose at that stage only to do arbitration either, because you need to gain the practice and the experience in doing all the range of commercial disputes, because they could be very wide. I mean, I think if I look at my practice over the last 30 years, it's ranged across energy, joint venture disputes, share disputes, construction disputes, international sales, all of them, both arbitration and commercial litigation. What it has, however, allowed me to do is to develop a practice also now as an arbitrator. And that, as a practitioner, is of enormous benefit because it allows me to be part-time on the other side of the table, part-time to be the tribunal considering disputes, but the rest of the time doing the advocacy. And I still love doing the advocacy, so I don't want to become a full-time judge because then I have to give that up. But I do very much enjoy, and I learn from sitting as a tribunal member as well, because actually you learn a lot about advocacy from listening to it. And even now, 30 years in, I'm still learning about advocacy. So that's been a fantastic benefit of doing it. And now I spend about 20% of my time sitting as an arbitrator. Sometimes it's a bit more, sometimes it's a bit less. And presumably, as I get more and more senior, maybe I'll start doing a bit more sitting, I don't know. To become an arbitrator, if that's something that might interest you ultimately, to be able to have that sort of dual aspect to your practice, essentially you have got to get involved in doing arbitrations. Because the way that you get appointed as an arbitrator is through one of the relevant appointing bodies, and they need to see that you've got experience of doing arbitrations. The reason for that is that the procedural rules are different. So each appointing body has its own set of procedural rules. They need to know that you've got some understanding of how arbitrations operate. In reality, the procedural rules aren't that different to many of the procedural rules that you find in High Court. I mean, they might be called different things, but they're broadly the similar sort of concept, because actually, ultimately, both the High Court procedural rules and the arbitral procedural rules are trying to get to one answer, fair resolution of the dispute. But you still need to have that experience. I think the other big difference, I would say, I mean, obviously, arbitrations are private. There is a viewpoint that there is more latitude as an advocate in an arbitration. Lots of solicitor advocates will appear in arbitrations, but they won't appear in the High Court because they think they have more latitude. That does depend on the nature of the arbitration and the tribunal that you're sitting in front of. But Kieron, one of the cases that Kieron mentioned that he and I did against each other recently, we had Lord Neuberger chairing it. I don't think you had any more latitude as an advocate in front of Lord Neuberger than you would appearing in the High Court. Most of my arbitrations, the seats, whether I'm an advocate or a member of the tribunal, are in London. That's a personal choice on my part because my children have only just got to an age where I'm able to leave them easily enough. But the other advantage is if you sit as a tribunal member, you can get appointed where it's English law, but a foreign seat. Sometimes parties do that because they're trying to pick a more neutral seat. Picking up on Kieron's point, I actually also have had arbitrations where I've been sitting on tribunals where EU law points are raised. He, in fact, tried a very ingenious one in the case that he's mentioned, but not successfully. And another, just to give you another example, I was sitting on a tribunal which was actually appointed from Dubai, and the issues were whether there was, in part, compliance with Saudi and Kuwaiti competition law. But Saudi and Kuwaiti competition law, both of them are based on EU law, and there was an undecided issue of Saudi and Kuwaiti law. So in fact, we had Nicholas Forward, who's a former judge from the CJU, giving expert evidence about EU law. Because the way we were being asked to decide this point of Saudi and Kuwaiti law was to try and work out what the EU law answer was. So you do get quite a range of international law issues that can come up, even being appointed as a English lawyer, either as an advocate or a tribunal member. And I've also had to decide international arbitrations where, for example, the proper law of the contract is Irish law, not English law, and you get expert evidence about Irish law, and you have to decide that as well. In terms of the tips that I would give anyone who's interested in developing this kind of practice, they're actually very similar to some of the tips you've heard before. First and foremost, and I 100% agree with Mark about this, do not specialise too early. Ultimately, given the range of cases that you can get in arbitration, you need to be a good commercial lawyer if you're going to be doing international arbitration, and you don't want to get into a very specialist field where you haven't got the ability to decide, address or decide a very broad range of issues. As Belinda said, attending and speaking at conferences is particularly important in the international arbitration field. You've got a lot of clients who don't necessarily know people and so want to see faces. As I mentioned, I get appointed through the Dubai LCIA, and they have, for example, pre-COVID, but they're starting again now, an international conference. It's a good thing to go and be seen. And as you get more senior, and if you're thinking about taking appointments, then the best thing to do is word of mouth. Speak to the people in chambers who you know are appearing in arbitrations, tell them that you're interested in an appointment. Speak to solicitors who you have, by this stage, known are capable of taking decisions about appointments, and just let them know that that's something you're interested in doing. And it will take a while, but if you've got some arbitration practice in your day job as the commercial advocate, then you will find that you will start getting those appointments. You sometimes need to be a bit careful about what appointments you accept if you get to that point. To be a bit careful about, I mean, it's an interesting thing sitting on a tribunal, because you don't know, if you accept the claimant's appointment, that comes first, and you don't know what the rest of the tribunal is going to look like. And I've certainly had an experience of sitting with a completely irrational Egyptian lawyer who, legal knowledge, very difficult, trying to produce an award that made sense, quite complicated. So I'm quite careful now sometimes about whether I accept claimants' appointments. If you accept a respondent's appointment, at least you know that there's one other sensible person on the panel. Obviously, if you're the chair, you know who the two panel members are before you get appointed. But you need to build up to becoming a chair. You won't get a chair appointment from any of the international arbitral tribunals until you've got a bit more experience. But generally, I would thoroughly, in terms of a career at the bar, is definitely a marathon, not a sprint. I definitely would commend everyone the fact that international arbitration gives you this ability to keep on developing your practice, even after 30 years. Thank you.
And finally, last but certainly not least, I'm delighted to welcome Naina Patel from my chambers, Blackstone Chambers. She was called to the bar by Inner Temple in 2005. She's widely recognised in a whole range of different categories of work, public law, administrative law, immigration, employment, competition, police law, and so on. The list is seemingly endless. Naina had an absolutely fascinating introduction to the legal world, and indeed has interrupted her career at various points to go off to Afghanistan. So just after I'd first joined Blackstone, Naina was around for very long because she was always in Afghanistan doing this amazing restructuring project with the Afghan authorities. She's a senior rule of law fellow at the Bingham Centre for the Rule of Law, and widely published as an author. Her extensive reconstruction work has also seen her travel to Rwanda, Kosovo, Azerbaijan, and other places. So it's very much a delight to have Naina speak to us today.
Thank you, Kieron. Really lovely to see you all and to be in the same room as other people. I am going to focus on public international law, which is one aspect of my practice, and focus on the particular way in which public international law appears in my practice. You've heard from Belinda and others that there are, I think, a range of ways that public international law, which is basically law between states, can feature in practice these days. You have pure public international law, which is cases like the claim that Ukraine issued in the ICJ today against Russia. Cases which can involve a state against an individual, most obviously regional human rights courts like Strasbourg that Kieron has talked about. Investor-state claims that Belinda and Helen have mentioned, which involve states against corporations or individuals. And then increasingly you have public international law issues arising in domestic courts. And that might be an issue of treaty interpretation, or it might be the invocation of an international human right in a domestic context, or an issue of state recognition in a commercial dispute in a domestic court. And I think the most public international law that I do is that last category, issues that arise in discrete domestic cases. Why did I want to do this work? I remember writing on my UCAS form, which was an application to read law, although I subsequently changed. I took Mark's advice and changed to PPE after 6 weeks of studying law. But what I wrote on my UCAS form was that I was interested in law as the cement of society, how it makes societies cohese and function, and be able to solve disputes peacefully without shooting guns. I then became interested in how law can be used to build and develop societies from positions of poverty to positions of greater development. And so developed this interest in essentially international development and law. And that led quite naturally, I think, to comparative law, looking at how different legal systems around the world might be responsible for how certain economies have grown better than others. And then international law, in terms of what conflict can do to countries and how people can recover from conflict and mediate conflict. And so what is interesting about public international law? It is really the coalface of law in international affairs, relationships between states, rich and poor, weak and strong, and raises issues like trade, diplomacy, human rights, and war. I think I was also very idealistic as well when I started as to what law could achieve, and I think you get gradually more nuanced in your views on that as you practice. How did I develop practice in this area? I did, in the end, a broad-based degree, politics, philosophy, economics. I then did a conversion course, and I then went off to do a more targeted master's. It was called a Master's in Public Policy at Harvard, but the arrangement there allowed you to take a number of courses at the law school. So it's there that I did my public international law, my international trade law, my international human rights law, and I sort of punctuated that with courses on democracy and social institutions and development economics, that sort of thing. I did an internship in Afghanistan. That was my first foray into sort of the realms of conflict and reconstruction work, and a thesis on Afghanistan, which ended up being probably quite formative in terms of what happened later. And I think it's an example of how you never know how certain decisions that you are going to take play out, and why Mark's advice, I think, about doing the things which interest you when you're starting is fundamentally sound advice, because you then enjoy it for the sake of it and continue to be passionate about the doors that it opens up into, because they all stem from something that you were genuinely passionate about when you started. I undertook work for an NGO while I was doing the BBC International Rescue Committee, which took me around lots of different jurisdictions to see how they were recovering from conflict and to learn a little bit about their legal system. And then I started pupillage and the early years of practice. And I think the reason that Afghan stint was significant was because when I started pupillage, we were at the forefront of all of these cases which arose from, firstly, the Iraq conflict and then the Afghan conflict. And I think probably not because I had anything particularly to offer other than a little bit of experience of the country, but more because I was sort of perceived as possibly the right fit for some of these cases. I became fairly regularly a junior on a lot of the claims that were being brought against the government about things that had been done to Iraqis or Afghans by British soldiers and others. And so that was sort of the beginning of dealing with some of these public international law issues like what is the interplay between international humanitarian law and international human rights law, and to what extent does our Human Rights Act apply overseas to the actions of forces in Iraq. I got involved in the Bar Human Rights Committee, and one of the things I think which is good to look out for is opportunities for bar associations, as Kieron's mentioned, and also pro bono work. And the Bar Human Rights Committee does a lot of pro bono work. I got involved in a 3-year project to do legal training in Afghanistan again, with Sam Knights in Mark's chambers, and a chap at Belinda's chambers, Sudanshu. So you get to meet a wide range of colleagues that way in different chambers with similar interests. And I got to obviously nurture this interest in Afghanistan. I did work for the UN Refugee Commissioner that has a pro bono panel of cases that's run by Baker and McKenzie. So I think for me, pro bono work has been probably quite a regular theme in terms of opportunities that it's created for working with international organizations and in different jurisdictions. So that was practice for, I think, the first 5 or 6 years. I then had the chance to go off to Afghanistan to basically run the rule of law programming in Helmand in the south. So I was living on a military base, dealing with some of these PIL issues in sort of the real world and trying to get the Afghan legal system essentially working. And when I came back from that year, I decided to split my time between practice and working in an NGO, and that was when I started working at the Bingham Centre for rule of law. And that involved a number of projects that raised comparative and PIL issues. There was a project about constitutional options for Libya, free speech in Bahrain, constitutional options in Burma, peace issues in Burma. And then I think the demands of family life struck, and I decided to focus very much on practice, which has been the last 5 years. So I don't have any extracurricular exploits at the moment. I try and manage my 2 children under 5 and my cases. I'm going to give you just a snapshot of 3 cases that I've done in the last year to give you an idea of what this public international law in domestic courts sort of looks like and the sorts of issues that it's thrown up and why I've found them interesting and rewarding. So the first case is a case that concerned the battle for control over 2 billion of Venezuelan gold reserves in the Bank of England. You may have read in the papers about the battle between Mr. Maduro and Mr. Guaido. This was a case that Belinda was involved in as well for the Foreign Office that intervened in the case. And the key issue that I was involved in was this issue of who is the head of state of Venezuela, because that determined who had appointed the board that gave instructions to deal with the gold. So really interesting issues about control or being head of state sort of in law versus in practice, the extent to which a court has to defer to a government that might have made a decision about who it recognises as head of state, and what the position is where there might be a decision recognising someone as head of state sort of in name, but the position on the ground may be a bit more complicated than that. So really interesting issues about the interplay between 2 different countries and then international issues and domestic issues. The second case is a case that concerned judicial review of a decision to abolish 2 VAT-free shopping schemes for visitors to the UK. I don't know if you remember being able to go to Boots at the airport and buy a stack of things and show your pass at the till, and if you were going to a non-EU country, the VAT was taken off. And that was scrapped in the wake of Brexit for reasons to do with compatibility with WTO law. And in this challenge, one of the key issues was the government's direction about compatibility with WTO law correct, or had it misdirected itself? So really interesting issues about the justiciability of what is technically an unincorporated body of international trade law, which we've not really used much in this jurisdiction before because we've had EU law. And we had Lord Justice Green, a big, very well-known competition law lawyer, who spent most of the 2 days saying, I don't really see the difference between WTO law and EU law, they're sort of the same thing. And why should it be the case that, you know, because it's unincorporated, we give it any less attention? So really grappling with this idea of dualism. And my client's case, which was that this body of law should be sort of fundamentally not justiciable because it's not part of our legal system in the way that EU law is. So again, really interesting set of issues, which is only going to be more a topic of debate and litigation in the courts, given that we now are sort of directly subject to WTO law and we are a member in our own right rather than through the EU. And then the third case is a case that concerned an appeal against the registration of a foreign judgment for sums due under an insurance arrangement following the loss of a ship off the coast of Spain. And I acted for Spain. And the appeal alleged that the underlying Spanish judgment that was being enforced had been obtained in breach of fair trial rights, so both Strasbourg rights and rights under the International Covenant on Civil and Political Rights. And the argument was that if you recognise this foreign judgment, it will be a manifest breach of English public policy because of the way that it was obtained in breach of these fair trial rights. So again, a very interesting set of issues. Are these unincorporated human rights treaty obligations part of English public policy? If they're not incorporated, can they be? When can a party, like an insurer, rely on the breaches of the human rights of a third party, in this case the captain of the ship, who had been the subject of the criminal trial that had resulted in the Spanish judgment? And can it be a breach of English policy to recognise a judgment where the same human rights complaints have been taken to the relevant international court, so here Strasbourg, and been dismissed as inadmissible? So again, you see these kind of different systems having to sort of grapple with how, you know, another jurisdiction has looked at the same issues. This court has to look at it. To what extent does it defer to Strasbourg that has looked at similar issues? And I think that's why I find it such an interesting area, because you are constantly looking at the interplay between not just bodies of law, substance and procedure, but also the institutions and the politics that are at play here. A couple of things about what's interesting and what's challenging about this sort of area. I mean, you are working on issues which are the cutting edge of current affairs. You can work for a range of organizations. That might be international organizations, states, foreign or domestic, companies or individuals. You learn, as Mark has described, about different jurisdictions, different sets of politics, different crises that are happening in different parts of the world, sort of afresh each time, so no day is dull. On the flip side, if you're the sort of person who wants to know one area really well, to be an absolute expert in clinical negligence, you know, this sort of a practice is probably not for you, because you are constantly having to learn new things. And I think, you know, it is hard to have a case where there will not be something completely new in it that you will really have to kind of get your teeth into and get up to speed on in rapid time. And I suppose the other challenge that one can have is that there is a place where law ends and politics begins. And not all of your cases will go to the most satisfactory conclusion where there is a judgment at the end of the day with a very clear enforcement process and a, you know, resounding result for your client. It can sometimes be a little bit more nuanced. You might win, but it might not always translate into the sort of concrete, tangible result that perhaps the client had wanted. Thank you.
Well, thank you very much indeed. What we've seen, I think, are a number of very different routes to the bar. If I could draw perhaps three overarching common themes that have emerged from the excellent presentations you've heard from the speakers this evening. Follow your passion would be the first one, and don't be afraid of trying new things. Find something that you are engaged with. Secondly, research the area thoroughly, research the procedural rules, the substantive law, and work at it so that you can then develop the expertise that our panelists have shown in their professional development. Finally, bar networking. So you've got the specialist bar associations, you've got circuits, you go out and do presentations for law firms, get yourself immersed in the area that you're interested in and become familiar with your colleagues, and they will be a support network for you. We do have a written question that's come in advance. I promise it's a genuine question, not one that we've made up with an engaged speaker in the way that they do in the House of Commons. Rishikesh Sharma has asked, what practical steps should one take to develop a practice between England and Wales and India, which I think the panelists have largely agreed it's quite difficult for us to answer as such. There are various rules that require you to be properly registered as a practitioner in India, so you would need to pass the exam there and be enrolled. Foreign legal professionals in India can basically only come on an ad hoc basis for a temporary period of time, and I think our mutual experience is it's quite difficult to pick up work in India unless you're coming in as co-counsel with an Indian lawyer. So it is a very large market, it's a very up-and-coming market in terms of international arbitration. There's plenty of work around, but actually getting into it's quite difficult. If Mr. Sharma would like further advice, then Belinda and Jenny have offered email contacts with people who are dual qualified at the junior end who may be able to provide some more substantive, concrete advice. Does anyone have any questions from the floor? Or Jenny can read something out off the internet, as long as it's decent. Great. Good.
Yeah, this is a question for Adrian specifically, but obviously if any of the rest of the panel want to weigh in as well. I was just wondering if you could give us some guidance, a bit more like Belinda said, of kind of practical steps, things we should be doing, things that like pupillage application committees and so on are looking for in the migration area to kind of build our practice to move ourselves towards work in that area. Thank you.
Yeah, no, of course. So it is at the bar, you often find people who've worked for NGOs first in the field of migration, or they've worked for refugee community organisations. So there are some organisations which focus on issues that touch on migrants' lives, like Freedom from Torture and Helen Foundation. Sometimes there are international networks of people who work on migration policy, or there are volunteer schemes in the Aegean to help people who have fled from Syria via Turkey into Greece. And so there are things like that which you do. And it's probably fair to say that there's a sort of field of NGO migrant rights activism. It's not just including people seeking protection, but people who are moving. And that some people who are interested in that area of public law often have experience doing that, and then patch in more into, they meet immigration, migration solicitors and barristers in that context. And so that's one way of doing it. Yeah, and in addition to that, I suppose in the UK itself, not just working overseas or working for NGOs, there are a number of organisations, particularly in London, that work specialise in the areas, the sorts of law, a bit like the Air Centre, the Advice on Individual Rights in Europe, and sometimes the Public Law Project are involved in some migration issues, and you can see that there are lots of things which you could try and, conferences you can go to, people you can meet, that start to develop your sense, your feel for that sort of area of work.
Thank you. I have a question related to something that didn't come up, but I'm still curious about, which is to what extent are foreign languages important or unimportant to building an international practice?
Should we ask Naina to deal with this, because she's probably been in the most countries, and then perhaps Belinda, and then I can give you some tips on how not to use French before the European courts.
I mean, I don't have anything properly fluent, apart from English. I cannot think of a time when it has been a problem, but I can certainly think of times when, I have been trying to decipher French documents or Spanish documents with my sort of moderate French and Spanish, and wishing that it was better. And I have definitely had times when I wish I had learnt Arabic. So I think it depends what you want. You know, if you see yourself as being an advocate in particular courts where there are multiple languages, and that is where you want to be in 15 years, then, you know, obviously it will make sense, if French is one of the languages of those courts, to have French. If you think you're going to be, you know, hopping around and being more of a generalist, and there isn't necessarily 1 or 2 or 3 courts where you see yourself being, you know, regularly appearing, then I would have thought it makes sense to, you know, if languages are something that interests you anyway, to focus perhaps on some of the more widely used international languages, again, probably French and Arabic, possibly Spanish. But, you know, if languages are not something that interests you, I don't think it's a bar to doing this sort of work. You know, there's lots of it that happens in English. And I would, you know, focus your time on the things which do interest you and building connections in the areas and with the organisations that are going to excite you.
I would certainly echo Naina's comments. It's something that's a real bonus, but not a necessity. I find French particularly helpful in some of the international work I do. Sadly, it's not good enough not to use Google Translate just as a backup, or to call on someone with better expertise. The other thing I would emphasize, in addition to courts that practice in multiple languages, or indeed arbitration tribunals, as is often the case, is sometimes in a particular area, you'll find that there is a client base in a particular geographical location. You know, civil fraud, Russia is an obvious example, and I'm sort of often envious of juniors who have that wonderful facility to read in that particular language for disclosure purposes or for the client relationship, whatever it might be. So always a bonus, I think, but it shouldn't let you hold you back if languages really aren't your thing.
Yeah, I would absolutely echo that. I mean, I only speak poor French, but and despite having had many Russian clients over a long period, can only say da and niet. But what I do know also is that there are multilingual, particularly juniors in my chambers, who speak Arabic fluently, who are using that very much as a marketing tool in the international arbitration sphere, and it is working. So if you have it, you will be able to, because, you know, if you're doing that kind of work, essentially all your clients are going to be international, so you will be able to use it to your benefit, but it's not a barrier to entry at all.
Yes, I've got one experience of being able to deploy French for a useful purpose before the European courts, which was relatively recently, in October last year. Question came in from the presiding judge in French. It was translated in English, but the translator got the translation wrong. And there was a tax silk sitting behind me who was simply listening to the English translation and answered the question wrongly. And happily, I had picked up enough French during my A-level to be able to realize that there was a missing knot in the translation. And I therefore intervened and said, I think the question actually was, and then put the question in English, and the judge agreed with me. I wouldn't dream of pleading in French because my French is not good enough. If your French is fantastic, then you can plead in French in Strasbourg or the European Court. But be careful, because if it's not your first language, then you can come unstuck. More generally, if you've got any language ability, you will find strange places where it suddenly pops up. So I did Spanish O-level years ago, and I was cross-examining an Italian witness once on an Italian document without having an Italian translator present, because the chap was fluent in English. And he misdescribed a word from the Italian. I looked at it, thought it was similar to the Spanish. Hazarded, as you're not meant to do, a question based on my supposition that he'd got the word wrong. And it came off. So you will find strange places where you suddenly deploy your language skills. They're certainly worth having, but as I think everyone has said, they're not essential. We've got various people. We've got one in the front row, two in the fourth row back. Should we work from the back forward? Thank you, Jenny.
Hi. I'd like to ask a question to what Naina said. When you said the law, and there did come a point where the law and institutions sort of ends and the politics begins, did you mean corruption, or did you mean like there's some way, some legitimate process of politics which sort of kicks into play?
Yeah, so, I mean, you could take that lots of different ways, couldn't you? But I think what I had in mind was that when you're looking at the international plane, enforcement is a lot more complicated than domestically. So you have, for example, there is a judgment from the ICJ, isn't there, about the Chagos Islands, and there is, a big question, I think, as to what will happen, because the actors on the international plane are states, and states effectively get to decide at the end of the day whether they comply. So it's, and that's very, very simplistic, but it's a very different situation to a civil judgment against an individual where there are bailiffs who can go round and, retrieve goods to the value of the judgment in order to make the judgment some good. So I think that's what I had in mind, that it can be more of a challenge to get to a clean and decisive outcome with the remedy that your client wants if you're litigating internationally rather than domestically.
Thank you.
My question is also for Ms. Patel. I was wondering, what was it about Afghanistan that made you grow so interested increasingly? And could you tell us a little bit more about your work there?
Yeah, so it's quite bittersweet given what's happened in the last 12 months. And I think probably, I now reflect on it as probably a real example of my idealism. But it was interesting. It was an interesting experience, partly because of the legal setup. So there are 3 legal systems in Afghanistan. You have a civil legal system, which is effectively based on, it has a lot of Egyptian inspiration. So the Napoleonic Code is sort of, the ancient inspiration for it. And you have written codes, which are modelled on the last king, who was in power in the 60s. You then have a Sharia law system, which is religious, and then you have a customary legal system, which often gets confused with the Sharia. So when you have these stories about customs like Bard, where the traditional story is you have 2 villages, one youth from one village fights with a youth from another village and kills them. And how do the 2 villages neutralize the dispute in a country where you don't have a state justice system? So you're reliant on non-state mechanisms for solving disputes. Traditionally, the way that dispute has been solved is by giving a daughter from the village where the oppressor came in marriage to a family of the victim's village. And there are lots of problems with that from a rights-based analysis. But if you try and look at it from the prism of a country which doesn't have a state justice system, and it's lawless, and you're trying to ensure the survival of the societies rather than the individuals, it has some anthropological sense, because you create a blood tie between the 2 villages and you neutralize the incentive for them to exterminate each other. And so I think I found it interesting because it is a place where these 3 different types of system, if you can call them legal system, I don't know, but these 3 types of system coexist, have waxed and waned over time. But your challenge, going in as someone who's supposed to be building a state, is to try and make it all look more like what we have here. Lots of questions about, the achievability of that, the sense of that, and all sorts of things. But it also makes you, as a practitioner in a jurisdiction like this, look at what we have here and really question how this has grown up here. I had a case, I kept on a couple of cases during the year that I was out there, and one of them was in the Supreme Court. And I remember sitting there as we were waiting for the judges to come in. The judges came in, we all stood up in the usual way. And I found myself thinking, why have we done that? It's not written down anywhere. That's not in the CPR. We stand up because it's a mark of respect and because it's an indication of the fact that we respect the people who are going to write the judgment, and we consider that we're going to comply, all of us, our clients, those sitting behind us, with both what they ask of us during the hearing and the judgment that comes out at the end. And how do you build that? Why is that the case in this jurisdiction, and how do you introduce that in another jurisdiction? So I think for me it just raised a lot of fundamental questions about why our system is the way it is, why other systems are the way they are, and how you get other systems to look more like this one, and the validity of that enterprise at all. So I was working for the British government as a civilian in a military bubble, trying to rebuild or build a justice system. So that the NATO mission was that it wasn't safe enough to have civilians working there on their own. So you would have civilians working with military around them and going out, trying to build the healthcare system, build the education system, basically to create the state infrastructure and a functioning state to persuade people that, to Afghans, that an Afghan state of a liberal, democratic kind that we all recognise was more likely to serve their security, their healthcare, their education interests than the Taliban regime, coupled with the customary sort of world that they'd been living in. And so I was I was mentoring prosecutors, I was setting up NGOs that would hire defence lawyers so that there were defence lawyers to then actually have an equal trial, trying to do trial observations, working on forensics. So, a lot of it was very practical. It wasn't litigation. It was sort of the more sort of tangible things about how you sort of create a system of justice. But it was, interesting for all those other different reasons in terms of the way that then influences how you look at a lot of the features of the system that you do litigate in day to day.
Final question, has that project come to an end, sorry, because of the current coup in Afghanistan?
So that was part of the British presence in Afghanistan. That particular mission in Helmand wound up almost a decade ago. So yes, that project is finished. And then, of course, much more fundamentally, whatever presence we had left, we have no longer got in the country since August. So yeah, it's completely finished.
So we're approaching the witching hour when this presentation is over. We probably have got time for two of the quickest questions the world has ever known.
Would you like us to take those from the online audience?
Why not? Yes. Sorry. Very quick questions.
We have 8 questions from online. I'm afraid I don't think we'll be able to get through all of them. I had one question. Wojciech Zaluska has asked Ms. McRae if her arbitration cases are generally on a public access basis or instructed by solicitors.
Good question.
Invariably instructed by solicitors.
Very
quick answer.
That's a very quick answer. Good. Next.
Next question I have is from Mohammed Hassan Arif. My question is to either Belinda McRae or Naina Patel. Considering the nature of public international law with regards to enforceability, have you ever come across a situation where it became difficult to enforce an award due to a state's refusal to honour it? And what is the remedy?
The short answer is yes, and the remedy is a very good question. I think it's often dealt with in a political dimension. It depends on the nature of the dispute. If it's sort of commercial, there are particular avenues one can adopt. If it's more human rights based, there are forums for that as well. But perhaps a rather involved answer in the circumstances required, so I might just leave it there unless Naina wants to answer more fully.
No, Naina doesn't want to answer more fully. Yes, and Naina's mentioned the Chagos case, which did in fact go to the Court of Appeal last year, where the Court of Appeal refused to give direct effect to an ICJ judgment, and the Supreme Court refused permission. Right, that I think draws to an end. Can I just invite you to show your customary appreciation for our excellent panelists this evening and join with me in thanking them? The strong advantage of being here in person rather than looking online is you can now ask us informal questions over a glass of something either alcoholic or non-alcoholic as suits you. Thank you very much indeed for coming.